Be ready. 5 seconds.
This is an application filed by the plaintiffs under Order 39, Rule 1 and 2 Civil Procedure Code seeking grant of an ad interim injunction preventing the defendants from passing off their goods as the plaintiffs in breach of the plaintiff's trademark Whirlpool. The suit was filed on 4/8/94. The plaintiff's application came up for consideration on 5/8/94. The counsel for the plaintiffs had pressed for the grant of an ad interim injunction ex parte. However, the defendants had entered in appearance and were willing to accept notice. Copies of the pleadings with documents were delivered to the defendants. The defendants filed their counter affidavit and have joined in hearing which commenced on 8/8/94. The documents filed on behalf of the plaintiffs are voluminous, preserved into several boxes. The defendants have filed a brief affidavit which only was possible in view of the short time available at their disposal. They have joined in hearing, reserving their right to file detailed affidavits and documents contesting the plaintiff's prayer. Instead of noticing their pleas in details, it would suffice to sum up the contentions on which they oppose the plaintiff's prayer and propose to defend themselves. They are 1. That admittedly the plaintiffs have not secured renewal of the registration of their trademark in India since 1977, the reasons being inconsequential. Admittedly, plaintiff number 1 did not have full-scale commercial use of the trademark in India. This would amount to abandonment of the trademark by plaintiff number 1. That the plaintiffs cannot claim the said trademark Whirlpool having become associated with the plaintiffs in the mind of the customers in India. Any right by user of any trademark in regard to trade and exclusive right to use the same by any person can only be territorial in nature. Nobody can claim exclusive right to use a trademark in a territory or locality where it has not sold the goods with the said trademark or acquired any reputation therein of any exclusive appropriation or use of the trademark. In addition, the defendants have set up the pleas of delay on the part of the plaintiffs in initiating the present action as a bar to the relief of injunction. It will be useful to notice the chronology of events in this behalf inasmuch as it would be necessary not only to test the plea of delay but also in another context. The same are set out in the succeeding paragraph. For all the foregoing reasons, IA 7657/94 is allowed. The defendants, their partners, trustees, agents, representatives, and assignees are hereby restrained from manufacturing, selling, advertising, or in any way using the trademark Whirlpool or any other trademark deceptively or confusingly similar to the trademark Whirlpool in respect of their goods. The plaintiffs shall within 4 weeks from today place on record an undertaking in the shape of affidavits sworn in by their duly constituted attorneys or representatives undertaking to indemnify the defendants from any loss or damage which the defendants may incur on account of these proceedings and determined in this suit or any other duly constituted legal proceedings in the event of the plaintiffs being held not entitled to the relief sought for in the suit. Nothing said herein above shall prejudice in any manner the rights of either party to have their pleas determined on merits after a full-fledged trial.